Alex here with part 206 of the My Docket series on child custody and visitation. As with my previous videos, I'll take this opportunity to direct my viewers to part 0 if you haven't seen it yet. That's the video that contains the detailed disclaimers and the underlying purpose of the series. Two things that I will glaze over are: number one, I'm not in the middle of this right now. My case is completely and totally over. It's closed. It cannot be reopened, and that's because my ex's parental rights have been terminated. Number two, the nutshell version as to the purpose of the series is to give my viewers one big example of my 8-year-long high-conflict child custody ordeal from beginning to end in chronological order. We go into the portion of the My Docket series that I like to call "You Can Run But You Can't Hide." And that is because the judge has granted my motion to serve my ex by publication. If you can't find your ex for personal service, a lot of people think that you just can't do anything about it. You're just screwed. That's not the case. The law has a mechanism called service by publication. I dedicated a separate video completely to that topic. So if you want to learn the technical details of service by publication, please watch my video on the topic, service by publication. But my mindset going into this was good, but I kind of figured it was going to happen. Like I mentioned in prior videos, I anticipated not being able to find her. I expected this to be a problem, and I had already planned to have to serve her by publication. And for all the same reasons, I guess maybe naively so, I expected the judge to grant the motion summarily. And she did. She granted it summarily. I think that's it really for the mindset portion. So let's go straight into what the judge has filed. Here we have the order for service by publication. As you can see in the upper left-hand corner, I prepared this order. If you want to learn more about proposed orders, watch my video on the topic, proposed orders. So I prepared this order for the judge, and she signed my order. Let's see, standard introductory paragraph indicating that these are termination of parental rights proceedings brought by me to terminate my ex's parental rights with respect to our common minor child. So number one, I'm the natural father of the child. I have primary physical and sole legal custody of the child. My ex has a limited right to supervised visitation, and her efforts to conceal her physical address from me stretch back through the entirety of our child custody proceedings. We have citations to my affidavit, citation to the petition for child custody filed in 2008. My ex initially obtained a fictitious address from the Secretary of State's Confidential Address Program. I responded by filing an original writ petition, and the Supreme Court of Nevada ultimately authored an opinion expanding Nevada case law. So this is a citation to the case that's named after me. That case is the gateway to challenging the Confidential Address Program. I followed up by filing a writ petition in the district court, which District Court Judge Chuck Weller ultimately granted. And you can see that I'm citing to the writ of mandamus. The Secretary of State disclosed to me my ex's physical address as ordered by the judge, and my ex's physical address, and gave me notice that my ex's fictitious address was canceled. Next, we have my ex's continued refusal to disclose her current physical address, conduct which ultimately resulted in the suspension of her in-person visitation. So you can see here where the judge connects her non-compliance in the context of the best interest factors to her non-compliance as is needed for the service by publication. To date, her address is not only unknown by me, but also members of my ex's own family. The district attorney was also unable to prosecute enforcement proceedings against my ex because they couldn't locate her. So this just underlines the fact that nobody can find her. Next, we have efforts to effect personal service on my ex at her former residential address and her place of employment were unsuccessful. We have a citation to another affidavit, and we have efforts to garner information on my ex led one of the process servers to believe that she may possibly be at her husband's address. So and I like this here. The second process server, the one in Hawaii, was actually a former investigator for the Massachusetts Attorney General, which is good because it adds to his credibility. I mean, if he was ever examined on the issue, it would add to his credibility. At this point in time, the judge just kind of has to take my word for everything. Conclusions of law. Service by publication is appropriate, quote, when the mother of a minor child cannot, after due diligence, be found within the state or conceals herself to avoid the service of the notice of hearing, unquote. Let's see, multiple affidavits. You can see here that I have complied with the technical requirements of the law, which are under 128.060 sub 1 and NRCP 4 sub E1I. And you can also see that I have satisfied the due process portions of the Constitution as required by Price v. Dunn. It's important for you guys to realize that sometimes the statutes aren't enough. You have to look into the case law to see if there's anything else there. And that's what I did, and I made sure to comply with that because I really did not want my ex disturbing any of this stuff after the fact. I wanted it to be airtight. Let's see here. We have all of my notifications to my ex, her family, and her friends about what I was going to do. And we have the court being satisfied that, notwithstanding the due diligence of multiple persons, my ex cannot be located for personal service. And let's see. The court cannot ignore the fact that my ex's efforts to remain concealed are in non-compliance of court orders and are contrary to the best interests of the child. The judge cites Exhibit 4 and for these several reasons grants my request to serve her by publication. Once this is granted, I no longer care where she is. Who cares where she is now? I just have to put this little paragraph in a newspaper, and just like that, voila, she's served. And that's exactly what I did, and that's exactly how we were able to proceed. For people who have an issue with this, I have a video called Service of Process is Not a Game. I don't know why some people in this country think service of process is a game of hide and seek. The point of the due process amendment to the Constitution is to just let you know that somebody is trying to take your stuff away. In the old days, apparently, the king or the government could just take your stuff. And the U.S. Constitution says you have a right to know that somebody's trying to take your stuff, and that could include property, money, or custody of your children. And you have a right to participate in the process, to resist it. There's nothing in there that says you're entitled to play hide and seek. Some people are really bothered by service by publication, and it's like, you don't understand the point of the 14th Amendment of the Constitution. It's not a game. It's not to go and hide and say, since you can't find me, you can't take my stuff. That's not how it works. It's just, you have a right to know. And so if you're playing games and you're hiding and nobody can find you because you think this is a game of hide and seek, and then the person's like, oh, well, I'm just going to try service by publication, then don't cry when your stuff gets taken anyway, because you thought that this was a game of hide and seek, but really you were just supposed to be to be told what's going on. And so you can be told that somebody's trying to take your stuff by all sorts of different avenues. You don't have to just be personally served with a piece of paper. You can be told through the newspaper. You can be told by email. You can be told by text message. You can be told by a guard at a gated community, literally. Why? Because the law says so. There's a statute in Nevada that says if you live in a guarded community and the guard won't let the process server through, well, guess what? The process server can just leave the papers with the guard, and just like that, voila, you're served. So please watch my video on the topic, service of process is not a game, and transition if you're one of those people. I understand that it just seems like a strategy. I think it's a pathetic strategy, but some people like it. It's a good strategy for some people. If you think that's a strategy, it's not a strategy. Don't play hide and seek, because next thing you know, they'll serve you through some other mechanism. You won't even know, and now you're in court. So all of this stuff being said, let's go into the next document here. We have affidavit of service. This is an affidavit of service by, it looks like, a third process server. So this one must have just been filed after all those other ones were covered. This process server personally served the petition upon my ex's brother just to let him know what was going on. I don't even think this was required, but like I was telling you guys, I wanted this airtight. We have another okay, so this is an affidavit by publication. This is different. As you guys can see, this one came from the newspaper. So the newspaper prepares this fancy little affidavit of publication. It looks different than normal affidavit of service. It goes over what was in the newspaper. It goes over the dates and times that it ran through the newspaper. And this shows that I have complied with service by publication. Next, we have a proof of service. This is me indicating that I have served. Okay, I see what this is. So a portion of the judge's order was to also mail certified to my ex's addresses. So she granted the request to serve by publication, and she also ordered that I serve her through the mail, which the judge can do because there's a statute that says so. In any event, I complied with the judge's order and the statute, and I sent the petition to terminate parental rights to all 3 of these addresses. Going into the aftermath, I filed 1, 2, 3 documents. One of those required me to serve by publication. If I remember correctly, and I'm just going to approximate, guys, if I remember correctly, service by publication was $300. I think I'm estimating kind of high. I feel like it was probably maybe 260, 240, something like that. But I'm not going to go track down all the dollars and cents and look it up. The aftermath portion of the video has always been kind of a rough estimate. So I'm going to go ahead and just estimate on the high end that I paid $300 in costs to serve my ex by publication. My ex did not participate in the proceedings, so she incurred $0 in costs. I didn't have an attorney, so I incurred $0 in attorney fees. My ex didn't have an attorney, so she incurred $0 in attorney fees as well. One big thing, just to let you guys know, we have a couple of videos following this, which are actually hearing videos. And as is my standard policy in the My Docket series, hearing videos will be through Premiere. So we will premiere those videos. Keep an eye out on the website. Keep an eye out on YouTube for those premieres to pop up. I am most likely going to set the premiere for Sunday at 3 p.m. most likely, and that's Pacific Standard Time. Keep an eye out for that. The 2 videos they're pretty short, guys. And I'm not going to leave you on hanging on a cliff. It's not going to be a cliffhanger because I know that would drive everybody crazy. I know that the first video is so short. It's less than 5 minutes. They terminated my ex's parental rights real quick. And so what I think I'm going to do is I think I'm going to premiere the first video at 3, and then I'm going to premiere the next video at 3:30. We should easily be able to fit both of those videos into one day, and that way you guys can go through 2 of the last 3 hearing videos at the same time. There is one final hearing video after both of these, which is an interesting video, and just letting you guys know this is not really over. I think there's going to be another 10 or 20, well, not 10, probably another 20 or 25, maybe 30 parts of the My Docket series after the termination of parental rights and adoption. So there's still a little bit more to go over. All of that being said, as with my previous videos, feel free to post any questions you have down in the comments below, and I will see you guys next time.